Sure, let's take a stab at many of those we can do without stretching this too far beyond our 12 p.m. stop time.
Absolutely. Okay, very good. Thank you. Let's see. Does the planning board have authority over changing road classes, such as from a class 5 to a class 6?
Absolutely not. No authority whatsoever.
Right. Okay, thank you. Can the planning board require a bond to complete roads in private HOA communities as well as for roads to be taken over by the town or the city?
Yes, the planning board can require roads that are being built as part of a subdivision whose road network is intended to remain private, although it's a little trickier because nowadays, if you're going to have a condominium project, that's typically where you'll see this kind of internal road network built. That might be part of the bonding that the condominium approval through the Attorney General's office may be required. And I know there's some statutory changes that are being proposed this year on that particular subject. But yes, the planning board is there to ensure there is adequate security to make that to ensure that the infrastructure to support the homes that are being built, it gets built. And that can include performance bond security, even though it may not necessarily become a public road in the future.
Okay, thank you. Is there a statute regarding establishing subdivision road construction standards? Not the specifications, but the duty to establish standards that are consistent with existing town roads.
Well, the statute that governs subdivision regulations, 67436, does contain an entry where the planning board, as part of its regulatory setup, requires suitably located streets of sufficient width to accommodate existing and prospective traffic. That within that language, and I'm reading 674:36 Roman 2E, and F also addresses, that, well, I think E mainly would be from which a planning board would derive the authority to require a road to be built to a certain standard. Now, the planning board doesn't have the authority over existing public roads and their construction standards. This drives the necessity that there be some harmony between the governing body, select board, town council, board of aldermen. They're in charge of existing town highways. The planning board is in charge of approving proposed new town highways. There really should be harmony between those two construction standards. So yes, you may have to work with the governing body to make sure that what you do at the planning board is consistent with what's done by the governing body, especially with regards to road construction standards. But I would mention a really good design that you should keep in mind is the geometric design standards for rural and suburban roads, which is available at the Department of Transportation. So if you type into Google geometric design standards, New Hampshire Department of Transportation, they're a really good tool to understand what is the sufficient level of improvement needed for roads based upon the amount of traffic on that road.
Very good. For clarification, Steve, we had a question in the chat. Isn't the planning board always the regulator of earth excavation?
No, because it could be the case the town meeting has decided to delegate that to the zoning board of adjustment or to the select board.
Okay, thank you. What parameters should be used for lot line relocation decisions?
Well, a lot line relocation, a lot line adjustment is sometimes called a re-subdivision, and the planning board has jurisdiction. I think the main thing is, you want to get, an accurate meets and bounds description of the new lot line, and you want to make sure that the adjoining lot owners agree and sign the subdivision plan, and then agree and require as part of the approval that there be a transfer of what amount of square footage is being moved from white acre to black acre. So those are the essentials that are really necessary as part of a lot line adjustment plan. I just want to say, I can't tell you how many times I've seen a situation where the planning board doesn't manage all elements of that and doesn't get it done, so that now suddenly 10 years later, the lot line adjustment plan wasn't recorded. the deeds transferring interest in land between the two parcels was never recorded, and you have a mess on your hands because you've got someone's trying to sell the property and they think there's a lot line that they're supposed to go abide by, but they're not sure. You got to make sure both property owners sign onto the plan. They both agree to the transfer of title, and that the town handles the recording of the transfer of title and the recording of the lot line adjustment plan. Don't give it to the applicants because they're not going to record it, and you're going to have a mess in your hands 10 years from now.
Yeah. And also just to throw in there that you have to make sure that the lot line adjustments aren't creating any nonconformities, right, Steve?
That's very true. You have to avoid that. That's part of the fact that the planning board cannot approve a plan that doesn't conform to the zoning ordinance. You cannot do that. The zoning ordinance is the standard. The town meeting has said this is what we want in terms of lot sizes, dimensions, setbacks, etc. And you have to make sure your approvals are consistent with and not contrary to the zoning ordinance.
Yep. Scenic roads. May the select board host the public hearing regarding removal of trees on a scenic road at the request by the utility company?
Well, there is a process where a utility company can get permissions, a different type of permission under the scenic road statute to remove a tree that's considered hazardous. So that hazardous declaration could come from and be of assistance from the select board. I would actually have to reread the statute, but there is a process where the utility company can kind of get expedited approval to remove a tree in a scenic road because of the need to ensure the reliability of the electrical system. But I don't know that it's true that the select board hosts it. It still may be subject to some kind of input from the planning board.
Okay. Andrea, if just make sure that that Steve answered your question, and to be able to follow up, let us know in the chat, and we'll get a follow up for you for that question that you had about the scenic roads. And let's see. I believe that Kathy, Steve answered your question regarding if a bond can be required to finish private roads. Offsite exactions cannot include visual impacts. Is there a way to include visual impacts on neighbors?
No. So offsite exactions are limited to drainage impacts. I need a new culvert. Highway impacts. We need a new XL or decel lane. Sewer and water impacts. We need to extend the water line or put in a pump station or any other related piece of infrastructure for existing sewer and water utilities. That's it. No more, no less. That you can't, visual impacts, no.
Okay.
Now, you could negotiate with a developer. Can't you put in a landscape berm or a fence or some other way to mitigate, say, the relationship between a commercial use and an adjoining residential use? That's part of site plan review, but that's not an offsite exaction. That could be something you would make as a requirement in the site plan approval of a project which abuts a residential neighborhood.
Okay. I think we have two people on the phone. If we want to take care of them, they've been waiting patiently as well to get their questions answered.
Yes, we have two people. Just for the sake of moving forward, if you are able to write your comments in the chat, I think it's more efficient for us to answer them that way, but we certainly understand that not everybody has the capability. So first I see Emily. I know you just put a chat in the chat box. I'm not sure if it's the same one, but I will allow you to, so you can unmute yourself in the top right-hand corner and ask whatever question you have.
Question. I'm wondering what the expected role of the town attorney is. Is it appropriate for the town attorney to debate the merit or question the merit of parts of the town zoning ordinance? And is it appropriate to tell the planning board that the applicant is correct and the planning board's interpretation is incorrect?
Well, ideally, the town attorney is going to represent the town zealously within the bounds of the law, but also give the planning board an accurate assessment of the merits of any particular part of the zoning ordinance. If the town attorney thinks some part of the zoning ordinance is inherently improper or doesn't conform to the zoning statutes or case law, the planning board, the attorney has the duty to give you that advice. And, ideally that advice is provided to you in an attorney-client communication session that's confidential to the planning board. So that's the attorney's job, is to give you that opinion about either the merits of an application or the appropriateness of any particular aspect of the zoning ordinance. And I would expect any attorney would do that.
Thank you. Okay, we have another caller patiently waiting.
Yep.
Looks like still, Katie. Thank you.
The last one is Bonnie Ham. You are now able to unmute yourself in the top right-hand corner and ask your question. Bonnie, are you there? Do you still know your hand's raised? We'll give you just a second, and then if not, we'll move on for the sake of time. Oh, I don't see her. Okay, we'll move on.
Okay, well, did one just pop up again?
Yeah, I see her. I'm not sure if she's trying to unmute herself or if she's just not there, but.
I'll do a chat question then, and we'll see if the phone person can get straightened out. Okay.
Okay. Yep.
Question, Steve, can you elaborate on the offline communications among planning board and between what it looks like the select board? What is appropriate communication outside planning board and/or select board meetings?
Well, what I try to emphasize is that I think the ideal is that the information the board is receiving is received by the board in front of anybody who's participant to the decision the board has to make. So the applicants and the butters are all in the hearing room when you're receiving the information together. And that's the ideal. It doesn't mean you can't have a member gather information to present to a later board meeting, whether it's a select board or the planning board. Doesn't mean you couldn't ask staff to gather information to supplement what the board is being presented so that you can make a sound decision. Again, select board or planning board. I just don't think it's a good idea for, board members who have to be in the decision-making role to be really actively engaged in that gathering process if you can avoid it. But, not all towns have the capacity to have paid staff. Or in a particular case, you may not have a situation where it's reasonable to ask the applicant to pay for special investigative studies. And I understand that some members might bring to the board unique circumstances and knowledge, such as they're an engineer or a lawyer, and they can do some research, but bring the fruits of their research back to the next board meeting so everyone can understand this is what's been gathered. This might have a material impact on the decision the board was make. That's really the best I can do in providing an answer about these outside investigations by individual board members.
Okay, we'll take one more chat question to kind of catch up with that because it's 11 o'clock, and then we'll get into the presentation and we'll do our best to get everybody's question. What procedure should the board follow if the 65-day decision period is near end and not all important information seems available or discussed?
So from my direct experience as a member of the planning board, my general experience has been that if a board is working diligently, moving towards an approval, and has done such things as, and this is what we used to do on our planning board, we treated the issues we had to address as a checklist. And typically we would try to give a preliminary approval on some of the issues which were non-controversial. Could have been the road layout, could have been the drainage issues, any number of things. And we tried to give a preliminary approval and then leave for the unresolved issues something that would be addressed later on. So what that does, it communicates to the applicant, I'm moving forward to a point where the board's going to issue a final decision in a reasonable period of time. And if you're doing that, typically when you very much find the necessity of having to get additional data, either from the applicant or if you're your own engineer, I've never seen applicants who are unwilling to give more time and give you an extension. And if you ask for an extension, get it in writing. Generally speaking, I think it's not that impossible to expand the time to consider something if you're working in a fashion reasonably with an applicant. On the other hand, and this works sometimes, if an applicant insists, I want a decision today, and you have a reasonable argument that the applicant's engineer has not delivered the data you need to make a final decision, you can say, well, okay, well, we can take up the decision on your application right now. I think a member here has a motion to deny approval of your subdivision. Would you like us to make a motion to vote on that motion, or would you rather give us more time to consider the application? Most of the time, applicants are more than willing to give you more time, especially where it appears the board is acting in good faith. The reason why you're not going to make a decision that night is because of a critical piece of data that's missing. I mean, and it may be something that you'd have to come back for a compliance hearing anyway. Even if you had you were prepared to give a conditional approval, let's say conditioned upon a final engineering review by the town's engineer, because the applicant came into the hearing for final approval with a changed roads design, and you're going to have the consulting engineer for the town review it to make sure it's copacetic. You're going to end up having a conditional that's going to require a SCLAR hearing and a subsequent review, because you can't make a decision based upon a discretionary judgment of that type. So it's hard to say, what do you do when you hit the 65-day deadline? It really depends on the circumstances. But if you've been working in good faith, my experience is applicants are prepared to give you more time, and maybe they'll give you a short leash. They may say, we'll give you another 15 days, and you may need to hold a special meeting. But, that's the process you might have to follow in order to not have someone go to the select board to order the planning board to do what needs to be done, which is the steps that you take under 676:4. So I hope that answers the question. That's kind of been my experience.
Okay, very good. We look like we're caught up with the chat and on the phone. So Steve, we can get into your part 2 here.
Okay, so moving ahead. Oops, I got to take control here. Okay. 1 second while I change the view. Okay, so this is my attempt to put together some of the other elements, what I consider to be the roles and responsibilities of the planning board. Many of these are driven by some of the characteristics of the statutes governing the planning board, and elements that I haven't already touched on with regards to planning board basics, which was mainly focused on the right to know law, disqualification, and the basic statutes that the planning board operates under in doing the business of land use planning in your community. The first of these is the planning board basic organization. It's important to know some of these elements and to know that these are the things that the statute dictates and how a planning board has to be organized. No surprise, the quorum of a planning board is always a majority. Planning board also uniquely, unlike the ZBA, has to have one regular meeting per month on a calendar year. So every planning board has to have a meeting during any month of the year. The chair and other elected officers are elected once per year. Members are either appointed or elected. There is one ex officio member in town, and also ex officio and administrative members in cities, and up to 5 alternates as approved by the town meeting. We'll talk about that in a second. Planning boards, like the Zoning Board of Adjustment, have to have rules of procedure, RSA 676:1. And if those of you who haven't accessed it, the Office of Planning and Development has a planning board handbook, and there's a set of rules of procedure, and I think it's Appendix B or Appendix C, I don't recall, that are really, really helpful as a foundation for your rules of procedure. And finally, most of the business procedurally of the planning board is going to be found in RSA 676:4. That's the principal statute that dictates the process you must follow in handling plats and subdivision plans, site plans and subdivision plans. Planning board has the ability to implement elements of its finances, 673:16. And there's a division of labor with regards to what that part of the statute that says the planning board can appoint employees. Yes, you can appoint employees and assign or hire consultants, but it's subject to the other corresponding civil employees, that's the same rules that govern other civil employees of the municipality. So in most municipalities, certainly towns, it's the select board who manages municipal employment. So the planning board ultimately wants to hire a planner who's dedicated to planning board activities. You would probably need to recommend someone to the select board who actually do the hiring, and that person is hired by the select board or the town manager, subject to the town's personnel rules. And then you also have the power to enter into contracts with planners and engineers and architects. You could sign contracts, but I wouldn't be surprised that some of the consultants might want to have it countersigned by the select board. But the statute does indicate the planning board can enter into those contracts. Planning board, I don't know how many planning boards are aware of this. The planning board can accept and use gifts, grants, or contributions, which is similar to what the Conservation Commission can do with regards to conserving conservation land. And then when the planning board collects fees, that's required to be held in a separate non-lapsing account and can't be commingled with other municipal accounts. And it has to be paid out under the authority of the planning board for specific activities, such as an engineering escrow account. Project is required to have an engineering escrow account. The payments from the account are paid to the engineer the town hires to review the road subdivision plans, whatever the case may be. So there's these elements of authority that help manage the cost levels, the expenses for and the hiring of people who will provide service to you as as a planning board, and also how they'll be charged to those who have to pay for some of these expenses in managing approval of subdivisions and site plans. Planning boards can have alternates, but I do have to emphasize that it is the town meeting that has to vote to have alternates and to authorize the appointment of up to 5 alternates by the governing body. If the town meeting has not voted to appoint alternates, if you have alternates, those alternates status may be subject to question. So just be sure that you have had a vote at town meeting. See if the town will vote to authorize alternates, up to a certain number of alternates for the planning board. Elected planning boards, on the other hand, if you're an elected planning board, they automatically have the authority, don't need authority of town meeting, automatically have the authority to appoint up to 5 alternates. The ex officio alternate for the city council or the town council, the select board, that person is appointed by the city council, town council, or select board. So it is very common. So the select board ex officio to the planning board has an alternate who is appointed by the select board, is not appointed by the planning board or the governing body. Alternates may participate as non-voting members. This wasn't the case until a couple of years ago, until there was an amendment to RSA 676:1. And I think it's useful to give some latitude to alternates to be able to participate rather than sitting at a planning board meeting like a potted plant, participate in discussions. They can't vote, but allowing them to participate, even though they're not appointed that night to serve in the place of a recused member, allows them to begin to get a feel for what it is to be a member of the planning board. Now, I see that the term ex officio is here, and I'll just mention, because I've got a lot of questions about that recently. Are ex officio members allowed to vote? What is the status of an ex officio member? And I would just remind everyone, the word ex officio does not mean I hold a subordinate status on the planning board, or for that matter, any other public body. The word ex officio just means I hold office here on the planning board because of the fact I'm a member of the select board. I held another office, and that's what ex officio means. It doesn't mean a member who has a subordinate non-voting status. Alternates are always designated by the chair, so one of the responsibilities delegated to the chair of the planning board is to make that designation. Who's going to sit for Steve Buckley, who can't be there tonight, as the alternate? And as I've already indicated, only the ex officio alternate may serve for the ex officio member. So that person who's been designated ex officio alternate for the regular ex officio member of the select board, that person is the one who's allowed to serve. So, for instance, in a 7-member planning board, the ex officio member is not there. So you now have a 6-member planning board that night, but the ex officio alternate is also not there. You can't then appoint another alternate to sit for the ex officio alternate or the ex officio member who's missing. You would at that night be able to, you would only have a planning board operation of 6 members. Those of you who are familiar with this statute, it's always important to be reminded of what it says. Any 2 appointed or elected planning board members can serve together on any other municipal board or commission, except No more than one appointed or elected member of the planning board can serve on the Conservation Commission, the local governing body, or local land use board. So recently this came up in a town where the town has an elected planning board, and there was a member of the select board who was elected, was still a sitting member of the select board, and then he got elected to the planning board, and he wanted to sit on the planning board along with the ex officio member from the select board. And the problem with that is, if that was allowed to occur, you would then have the elected member of the planning board who's a member of the select board sitting on the select board, and you'd have the ex officio member of the select board sitting on, of the planning board sitting on the select board, and that's not allowed. So this multiple membership of planning board members on not allowed. You can't have more than one on the planning board, Conservation Commission, or the local governing body is something you have to abide by and be aware of, especially when elections or appointments are taking place. I strongly recommend that planning boards mandate preliminary review if so authorized by the legislative body. And preliminary review can either be preliminary conceptual consultation or design review. If you want to mandate that there will be no site plan or subdivision application allowed in our town until the applicant first goes through conceptual consultation. If you want to require that, which I think you should, you have to have the town meeting vote under RSA 674:35 to require preliminary review. And there is a huge benefit to having preliminary review because before the applicant has to spend a lot of money in preparing subdivisions or site plans, you can get the applicant in front of the planning board in a non-binding discussion. You don't have to notify abutters. It's an informal give and take between the planning board members and the applicant. This is what I want to do. What do you think? What are your concerns? And try to shape something that was going to eventually turn into more detailed plans at some expense for the applicant at a later time. So I strongly encourage, if you can, get your town meeting to give the authority to require preliminary review and then mandate preliminary conceptual consultation in your subdivision and site plan review regulations. Design review is a little bit different. It's still non-binding. You know, it's a butter and published notice required, but there's no public hearing. And I'm not real familiar with the process, but it is a more aggressive form of preliminary consultation, short of submitting an application as an accepted and completed application and undertaking the actual review process for subdivision and site plan approval. So those of you who are familiar with the step-by-step process for a formal application, it starts with filing a completed application with the board, then has to be reviewed and determined to be complete. And then the application is assessed based upon a checklist in your regulations. And you may at the same time make the determination preliminarily of what's the likely costs and expenses the applicant would be expected to cover in terms of the board's expenses in reviewing the application. And eventually the application can only be accepted at a public meeting with a butter and published notice requirement. I guess I would give you the following observation with regards to how you determine that an application is complete. Does it worth taking the time to submit the application to then schedule a hearing for plan acceptance? Staff might do the internal interpretation of the checklist to make sure the materials received meet the checklist, and then would schedule it for plan acceptance. Preferably, the staff would be at the planning board meeting to recommend or not recommend plan acceptance. The other way you could do this, if you don't have staff, you could use the conceptual consultation process to go through the checklist with the applicant and try to give that person's guidance as to whether or not they've met the requirements with the checklist. So therefore, if they come back with an application with what was discussed at a conceptual consultation, it is likely the case that the plan will be deemed completed as a completed application at a public hearing. Just as suggestions for how to deal with that issue. If you don't have staff on hand who can help address these issues at town hall before the matter is submitted to a public meeting for plan acceptance. Those of you who are familiar with the planning board process, this is not terribly new, but it's important to go through the step-by-step for the timeline of decision under RSA 676:4. So preliminary consultation, there's no time limit for reviewing an application through preliminary consultation. You can have one or more meetings with the planning board under conceptual consultation. If, however, they've submitted the application and it's met the checklist, the application has to be submitted if they're going to get under the next public meeting or hearing of the planning board has to be 21 days before that acceptance meeting. And then, of course, notice has to be provided to the public 10 days before the meeting before plan acceptance. And then you have to hold at least one public hearing and make a decision to approve or disapprove within 65 days of plan acceptance. Most planning boards typically will schedule plan acceptance and the first public hearing for the same night. Now, of course, you don't know whether or not the board is going to vote to deem the application complete, but if there's some preliminary assessment by staff or maybe a conceptual consultation, you may have a pretty good idea the application will be deemed complete. So it's prudent to schedule plan acceptance and the first public hearing for the same night, with the understanding that the board will move into and open the public hearing if the board votes to accept the application as complete. And then within 5 days of it making a decision at a board meeting within that 65-day deadline, you have to issue a written decision. One thing I would mention about this timeline for decision, because if someone is aggrieved by your decision to approve or disapprove a subdivision or a site plan, they can appeal now either to the Housing Appeals Board or to the Superior Court. However, within that 30-day window from the time of decision to the deadline for filing an appeal, the planning board has the ability on its own to decide, we need to rehear this case, or we need to reconsider our decision, or you may get a request along those lines from an applicant. But the planning board has the inherent authority to decide, we're going to take that application back before the appeal deadline and schedule it for further hearing by the planning board. So that's a consequence of a decision involving the city of Nashua, that you have that inherent authority. There has been an amendment to a statute that modifies these planning board deadlines. So to the extent the planning board has to consider whether or not a project is one of regional impact, the planning board under this amendment to RSA 676:4 is now given an additional 30 days if a DRA, development of regional impact judgment is made about a particular application. You do get an extra 30 days for making a final decision. So keep that in mind. And I think, in part, this might incentivize more planning boards to reasonably take into account, is a project of regional impact, so they don't get worried about the fact that, as the statute contemplates, and I'll cover in a slide in a second, you really have to stand still once you've made a development of regional impact conclusion that it is a DRI, notify the regional planning commission and the abutting town. You have to stand still and take no further action on the application until they've been given notice and have an opportunity to attend the next public hearing. So this additional 30 days, which was granted with a statute effective August 9th, is certainly beneficial in that regard. Planning boards also can have alternative site plan review, approval, and review procedures. One of the things that the town meeting or the city council or the town council can do is authorize the planning board to delegate minor site plan review for minor site plans to a committee of technically qualified administrators. Now, the statute's got a lot of steps in it, but it allows those administrators to make approvals of minor site plans subject to potential appeal to the planning board. So that's one option to modify some of the work that goes to the planning board directly and would instead go through this committee of technically qualified administrators for minor site plans. Some towns also have technical review committees or groups that provide advice to applicants on their proposed projects. In an interesting case involving the city of Rochester, Martin versus Rochester, the Supreme Court made clear that committees composed of town staff that only provide advice to applicants, not to the planning board, to applicants on how to process their application. That committee is not a public body. So members of the public are not entitled to attend because the advice was not given to the planning board, it was given to the applicant. Something important to keep in mind. The other thing I think it's always a good thing to be aware of is the ability of the city council or the town council or the planning board to establish thresholds based on the size of a project or a tract below which site plan review shall not be required. So this would most commonly occur where you have an approved site plan, and now someone who's got, for want of a better example, a strip mall, and maybe it's got 5 or 6 units, and they want to modify one of the units, add a certain amount of square footage to that unit. And your regulations might provide or could provide that so long as the amount of additional square footage added doesn't exceed, let's say, 500 square feet, maybe 1,000 square feet, we're not going to require you to resubmit to site plan approval for a modification of that approval. So I think there's merit in understanding that, there's time and expense in coming to the planning board for approval, and perhaps it's appropriate for de minimis, and again, I suppose it depends upon your definition of what's de minimis, for minor changes to site plans to not require a modification of approval. But to the extent you do that, that would be initiated either by the city or the city council or by the town meeting or by the planning board. And you would set those de minimis standards not requiring further site plan review in the site plan review regulations. Acceptance vesting is an interesting element of the process by which the planning board makes decisions on subdivisions and site plans. And the event that's important to that process is the date that you deem a project to be a completed application. And this statute makes clear, once you've deemed a project to be a completed application and it's in the approval pipeline, let's say, that project is only subject to the rules, regulations, and zoning ordinances in effect at that time. And if during the project review process, after plan acceptance, the town considers changes to the subdivision or site plan regulations that could be applicable, or the zoning ordinance, those amendments would not apply to this project that had been deemed accepted prior to the first notice of those changes, if it's, say, a zoning amendment. Important to keep in mind, because I think fairness dictates we've accepted your plan based on the rules in effect at that time. And if we change the rules, those new rules will not apply to you. They will only apply to other projects, but not to this one that was already in the pipeline. And it's kind of a sensible theory of fairness in the land use process. And I call it acceptance vesting. We're vested from subsequent subdivision, site plan, and zoning changes once my plan is considered a completed application. So developments of regional impact. I think it's an important statute to keep in mind. So if you've got a project that's come to your planning board, and this is the statute, governing statute is RSA 36:54 to 57, because of its size and number of dwelling units, or its proximity to a neighboring community, or related transportation networks, or anticipated emissions such as light, noise, smoke, odors, or particles, proximity to common aquifers or surface waters, or shared facilities due to the nature of the relationship between adjoining communities and those shared facilities, it could be deemed a project of regional impact. And I think it's important, maybe at the conceptual consultation process, if you're using that process, or at plan acceptance, that a deliberate decision be made. Is this a project of regional impact? And if it is a project of regional impact and the planning board says it is, I think you would not open the public hearing. You would say at the plan acceptance, this is a project of regional impact, and you would stop the process of considering the application until you've provided notice to the Regional Planning Commission and the adjoining communities, and then you'd resume the public hearing process with them. I think it's a 14-day time period after they've been given notice and they've been sent copies of the proposed plans. And that's in part why that statute allows you to have an additional 30 days if you do that. So that's what the development of regional impact statute it has the expectation imposed on a planning board, and it also imposes the duty on the zoning boards of adjustment. And I would just say that if you don't consider a project one of regional impact, and it really is a project of regional impact, there's at least one Superior Court judge who has decided failure to deem a project one, which in that judge's opinion was one of regional impact, could result in a finding that any decision by the planning board on that project could be thrown out for not complying with the statute. So it is an important step in the process, and I think it is something that should be part of what a board would consider at plan acceptance. Is it a project of regional impact? Once a project has been approved by the planning board, I'll restate that. Let me back up for a second. This is my slide on one bite of the apple. So once a subdivision or site plan has been disapproved by the planning board, a second application for the same development cannot be considered an approved unless it is materially different in nature and degree from the first application. And this is actually a principle which is true for zoning boards of adjustment. Once the zoning board of adjustment has denied a variance, the applicant for that variance or someone who owns the property in the future who seeks the same variance and it's not materially different and the neighborhood is not materially changed cannot get that relief because it automatically has to be rejected under a case entitled Fisher versus Dover. So that principle has been applied to planning boards. So keep in mind that could be an aspect of the decision-making process the planning board may have to take into account when it has an application come before it that is the same as one the board had previously said no to. What you can do, however, and this is described in the case of Culloch versus town of Winchester, if the planning board receives a subsequent application for something that had been previously denied, if it was sufficiently different that the second site plan was modified to address the concerns that resulted in the original denial, then it's okay for the planning board to take up the application. And that's an important part of the reason why when the planning board makes a decision on an application, it has to not just say, no, we're not approving this. You have to say, no, this is the reason why we're not approving it. And that's part of the decision-making process that is part of the obligation the planning board has, so that an applicant could resubmit the application with the changes deemed necessary that was evident from the first denial and then move forward because this is now a modified plan that is meeting the concerns the planning board had originally. Planning board has the ability to require applicants to pay for third-party consultants. This is under RSA 676:4-B. I think the key elements of that statute, which I brought up here on the slide, you can require it for a consultant review, construction monitoring. You got to make sure it doesn't substantially duplicate any review at the ZBA level, if that occurred. Not uncommon if a project needs zoning relief or some other change or modification, special exception, as the case may be, they will typically seek that relief from the ZBA first and then come to the planning board. There may have been the receipt of some consultative evaluation paid for by the applicant in front of the ZBA. You can't duplicate that when the person's in front of the planning board. A couple of things further, I think, that merit attention under 676:4-B. The applicant can, when they think it's appropriate, ask that the planning board choose a different consultant. So the statute has this provision that if the planning board has said we use XYZ engineering firm for all of our reviews, the applicant can say, I have a reason why XYZ engineering firm has inappropriate negative attitude about my company, and I really would wish you to think about using a different consultant for engineering reviews. And so the applicant can make that request, and the planning board then has the duty to reasonably exercise its discretion whether to grant a change in the engineering company that will be doing the reviews for the town. So just an interesting element of the consultative status of people who are doing work for the planning board that you may have that occur, and you have this duty to reasonably take into account the applicant's argument that XY engineering firm has a negative point of view about the applicant, and that the planning board should consider using a different engineering review for that particular application. As you go through the process of approving a subdivision or site plan, it is not uncommon for a planning board to be requested to waive either a subdivision regulation or a site plan regulation. But you have a duty under these two statutes, 674-36 Roman 2N for subdivision and 674:44 Roman 3E, to only consider and grant waivers of your regulations under this provision, which includes the requirement that the waiver only be granted after a majority vote of the planning board that you find strict conformity of the regulation poses an unnecessary hardship and would not be contrary to and the waiver would not be contrary to the spirit and intent of the regulations, or the specific circumstances on this particular project or conditions of the land indicate that the waiver will still properly carry out the spirit and intent of the regulations. So I think prudence dictates that as waiver requests come in, you try to, and you could use really the content of this slide as a form for each waiver of the regulation, and fill in the regulation that's being waived and make sure the board deliberately addresses one of these two requirements in deciding whether to grant a waiver of the regulations, because that is a necessary step when someone wants to deviate from the regulations for subdivision and site plans. Few things about the public hearing process that I think that merits attention. As we've previously indicated, the planning board has to have rules of procedure. Those rules of procedure should, as much as possible, be impartially followed by the planning board throughout the whole process. Amongst other things, the planning board has a duty to hear certain people, which I'll get into in the next slide. So clearly those who are applicants, abutters, and others with that direct interest are entitled to be heard, and then the planning board might hear from others other than those who are applicants, abutters, or those with direct interest. The job of doing this process of public hearing is really managed by the chair, and it's the chair's duty to maintain order and to ensure that procedural rulings are addressed in a proper and fair fashion for all concerned. Ideally, your rules of procedure would help the chair do this because it will lay out the step-by-step process. Who's heard from first, how those who are heard in favor are then allowed to speak, those who are opposed are allowed to speak, those who are opposed, the applicant is allowed to have a rebuttal and surrebuttal, as the case may be, from those who are opposing a project. So just a step-by-step is an important element of the rules of procedure, which allows your planning board chair to follow it in a consistent pattern from application to application. During the hearing process, I think it's probably the better practice to make sure that all questions that are coming to be submitted to the applicant or an abutter, whoever the case may be, or to staff, really has to be going through the chair rather than there be direct question and answer between those in the audience and either individual members of the planning board or applicants, as the case may be. It really should be directed to the chair of the planning board. I think that part of the public hearing process should also have time limits so that, when people are allowed to participate at a public hearing, there should be an initial set of time periods that are allocated. Now, I've seen it done sometimes where an applicant is allowed to make, say, you've had plan acceptance, and now the board chair is opening it for a public hearing, and the applicant is allowed to make an initial presentation on their proposal to be considered by the planning board. I don't think it's unreasonable to set a time limit for that, because I've certainly seen more than once it becomes a situation where the applicant consume so much time, it becomes almost a filibuster, absorbing all of the time for that particular public meeting that night. So I think having a time period allocated, maybe it's 15 minutes, reasonably to limit the amount of the initial presentation, and then also have time limits on those who are speaking further either in support or as abutters, because I think it's reasonable to have time management goals set in your rules of procedure so that the board can proceed within a reasonable period of time. Most of your meetings are in the evening, so you don't have to have late evening meetings. By the way, I think one of the other rules that we used to have on our planning board, it's said as follows: the planning board will not take up a new matter after 10:30. Because if you're in the middle of a contentious public hearing and it's 10:30, you have to be clear to everyone. If we haven't reached that element of the agenda where your application's on it, we're going to have to continue that to another meeting, because you can't reasonably expect planning board members to make sound decisions at 1 o'clock in the morning. And I've been there before, and it's just not appropriate. So having a time limit as to when new items will be taken up on the agenda, again, would be something you would cover in your rules of procedure, and which I think is a good thing for planning boards to consider to have an effect to control against having very long and late night meetings. Then finally, I do have on here Riggins rules. Those of you who know about Riggins rules, Fred Riggins was the chairman of the Planning Commission, I believe, in Phoenix for many years. You can get them from the Office of Planning and Development. They're also available online. They're an excellent set of aphorisms and suggestions for how to be an effective member of the land use board. And I encourage you all to take a moment to go over those as a guidance to be a member that effectively delivers planning services for your community. As I've already mentioned, there is a particular set of list of people who are entitled to be heard in planning board participation. RSA 676:4, I've listed here. So at any hearing, the applicant, abutter, the holders of conservation, preservation, or other preservation restrictions, or any person with a direct interest in the matter may testify in person or in writing, and other persons may testify as permitted by the subdivision regulations or the board at each hearing. I just would caution you, if you have people who aren't abutters or don't have a direct interest, and they're there, I think it's, going to be difficult to say they can't speak, because you might be accused of content discrimination, and there are rules that govern open hearings because they're considered limited public forums under the First Amendment. And if you are engaging in content discrimination by preventing some people from speaking, even though they're not abutters, have a direct interest, you might be accused of violating the First Amendment. So I think you should exercise as much latitude as you can to allow other persons to testify as the board exercise that discretion to permit them to do so. The whole deliberation and weighing of the evidence process, I have a number of suggestions for things to keep in mind. I would encourage boards to, as much as possible, get all the information you need before closing the public hearing. So you really should have a deliberate endpoint of the gathering of information by closing the public hearing, so the matter is brought to the board for a decision. So make sure you've got what you need before you close the public hearing. The board can deliberate and vote at a later meeting. So if it's 11 o'clock at night and you've closed the public hearing and you really want to think about what's taken place, either that public hearing or prior public hearings, it's okay to continue it so long as you have time within the 65-day window, or get an extension to have another public hearing scheduled for a later time to then make a sound decision based on what you've heard at prior public hearings. Certainly, while an application is pending, you should, as much as possible, avoid ex parte, that is, contact outside the hearing room with individuals who are parties to the application. And you should try to, as much as possible, make sure your deliberation takes place at public meetings, not outside the public meeting. Both the case law and statute recognize that planning boards can rely on their personal knowledge of either the area under consideration or just personal knowledge they have generally about the subjects at hand in a particular application. And you're not bound to accept the conclusions of experts. But if you are going to reject the conclusions of experts, you have to have a sound basis for doing so based upon something then more than just personal opinion. And the planning board cannot ignore uncontradicted expert testimony. And the Condos East case reflects the Supreme Court's statements to us as land use board members that if all of the experts in a case, and Condos East is an example of that, are saying you don't need a second means of egress, another road into a project. There's a primary road into a project, and the planning board thinks we need to have a subsequent, another road into the same project on the back end. And if the town engineer says you don't need the second means of egress, and if the applicant's engineer says you don't need the second means of egress, and if the engineer the public works director for the town says you don't need the public and second means of egress, and everyone agrees you don't need it, and if the planning board says we're going to have it anyway, then that's going to be overruled by the Supreme Court. You basically can't do that. And that's indicative of what the Supreme Court said in the Dartmouth versus Hanover case. Those of you who know about this particular decision from 2018, it all was a debate about the construction of a significant new athletic facility in the on Dartmouth College campus adjacent to homes in the town of Hanover. And the real debate focused mainly on the fact that the size and dimensions of the project were allegedly going to create a diminished amount of sunlight to the homes nearby due to the size of the building and how it would shade their homes from access to sunlight. And ultimately, what the Supreme Court found was that there was no support for the planning board's decision that the building would in fact do that. In fact, this is unusual, but it could happen in this particular case. It did. The applicant had a sunlight expert, that an expert who was able to give the dimensions and degree of angle of the sunlight at that particular latitude and how it would be affected in terms of the light going onto the nearby homes and given the size of the building. And that sunlight, the way the sunlight would move in that particular setting, given the size of the building, and that particular opinions expert would not diminish the amount of sunlight during the winter months on those homes. Planning board said, ultimately, I think it'd be fair to say, we disagree based upon their own personal opinions. And the court said the planning board cannot rely upon lay opinions and anecdotes to refute uncontradicted expert testimony. And the planning board can't take their own judgment as to whether or not application has satisfied rules and regulations. One of the other things in the Dartmouth versus Hanover case was that staff had read the application and determined that it complied completely with the town's regulations. And that was not sufficient for that particular planning board decision, and the court overruled it. So in order to rely upon a judgment that we think this application is at odds with our requirements, it has to be based upon written requirements, not personal opinions of the planning board. Although I would contrast that with the Somahoma versus town of Tilton case, which is an interesting case from a number of years ago, which said when the planning board in Tilton opined that a proposed, I think it was a project that was going to have the sale of campers, and this particular retail outlet proposed to have a very tall flagpole with a very large American flag on it. And the planning board concluded that the 90-foot tall flagpole was expectations for the town in that part of the commercial district and refused to approve it and would have only approved a smaller size flag and a smaller size flagpole. And the applicant appealed saying, you can't do that. It's not in your regulations. And the Supreme Court said, no, that's not true. The role of site plan review was to ensure the uses are appropriately designed and developed, and that we're not going to say the planning board is restricted in making that kind of a judgment. But this particular flagpole and the size of this particular flag was inordinately inconsistent with the area in question and inconsistent with the general principles of our site plan review. So when the planning board said, nope, we're not going to approve that size flag and size flagpole, the court concluded the planning board was properly exercising its authority to impose conditions to support the site plan review regulations. So I just would I think if you read side by side the Somahoma case and the Dartmouth versus Hanover case, the reason why Somahoma was decided the way it was is this was a decision which was consistent with the general view that the site plan regulations were intended to create harmony between uses and the uses that were being proposed under site plan approval. The other case I think that is also indicative of the degree to which the planning board or a zoning board of adjustment can exercise input on the assessment proposed by applicants' experts to support an approval is the Three Ponds Resort case. So one of the things that the Supreme Court did in the Three Ponds Resort case was to distinguish the Condos East case and Continental Paving rulings. Continental Paving is a case where the planning board relied upon general fact sheets provided by the I believe it was Society for the Protection of New Hampshire Forests on what are or are not vernal pools. And the Supreme Court rejected the reliance on those fact sheets to overcome the opinion of an expert soil scientist. In contrast, the Condos East and Continental Paving case, in this particular case, the ZBA was being asked to approve a very significant enlargement of an existing campground. So they were adding, I think, as third as much more campsites than there were already there on a particular campground, a seasonal campground in this community, the town of Milton. And one of the key elements of the decision-making process is whether or not the road going into the campground that was going to have suddenly more traffic was adequate to support that traffic. And in this case, what the Supreme Court said was adequately supported were criticisms of the traffic study done by the traffic engineer, pointing out that the traffic engineer, which was evident from the report submitted to the ZBA, had done his traffic study not at the peak traffic time on that road in July and August, but it was done in May and June. So the underlying assumptions for the traffic report was not really reflective of when the most concern would arise for use of the access road during the peak summer travel season in July and August. The other thing that was very important about the case was that one of the ZBA members himself was able to give direct testimony that he had been on that road during the peak travel season, that there were many people parking on either sides of the road, making travel on that road for pedestrians and bicyclists somewhat impaired in terms of line and sight, and that based upon the fact that that was the existing conditions of the road, adding that much more traffic by adding a third as more campsites was likely to make the road use even more impaired for public health, safety, and welfare. So yes, the personal observations and reasonable criticisms of an expert report can undermine the report and allow a land use board to disagree with the expert, even though the town did not have a competing traffic engineering report to support the ZBA's decision. The planning board, when it makes these decisions and assesses all of this information, obviously has to have a written notice of decision. That is a key element of the final conclusion of the gathering of information and the assessment of perhaps expert reports. So you have to have a written decision, and you have to give written reasons in the event of disapproval. You can't just say, no, we're not approving this site plan. You have to say the reasons why, so they can come back, as in the Cullex case, and resubmit an application, perhaps to meet the concerns the planning board expressed as the reasons why the application was denied. So there has to be a decision that either approves with conditions, or disapproves. And if you're disapproving an application, it has to state the reasons why. And that decision and the meeting minutes must be on file for public inspection within 5 business days of the board's final vote. And a tie vote is not a decision. So if there, for some reason, you have a 7-member planning board, and that night you have 6 members present, and there's a vote 3 in favor and 3 opposed to approve the project, that is not a decision. Or 3 in favor and 3 opposed to deny approval of the project. At that point, you have nothing. There's no decision. The board has to continue working to eventually have at least 4 of the members vote one way or another to approve or disapprove the application. A tie vote is insufficient under all circumstances in terms of the decision-making obligation of the planning board. When you make a planning board decision, you oftentimes are making a conditional approval. One thing I would just emphasize more than anything else, because I've seen planning boards do this, they'll have an applicant make a representation. We're going to put in a small play area for the children called a tot lot in this area, or we're going to install certain landscaping or other elements. None of these elements appear on the planning board, the plat. They're just representations in the application. A representation in the minutes is not binding until it's made a condition of approval. So make sure you write down all these representations as the conditions of approval. Those conditions have to reasonably relate to the compliance criteria set in your regulations, subdivision or site plan. You might have standard conditions. There are many towns that I've represented have a standard set of conditions for all approvals. One of them might be before construction starts, you have to have a pre-construction meeting or a number of other things of that type. Conditions precedent are things that have to be taken care of before the planning board chair can sign the plan. A condition subsequent is something that's going to bind the use of the property, such as you're not going to allow truck deliveries between the hours of 11 p.m. at night and 6 a.m. in the morning, or similar things that are going to bind operation and use of the property in the future. As I said before, if you have a situation where, and I've seen this many times, we're going to approve this plan subject a conditional approval, let's say it's a site plan, subject to final engineering review by the town's engineer because the applicant came to the final hearing with some tweaks to the plan. You want to have final engineering review of those changes to the plan. You've granted a conditional approval. Those reviews now have to come back to the planning board as a supplemental report from the town's engineer. You cannot just have the planning board chair sign off on it once those changes are approved by the town engineer. You have to have a compliance hearing, sometimes known as a SCLAR hearing, so that you can then review what was submitted as a supplemental report from the town engineer, because that's a discretionary judgment that requires a planning board subsequent public hearing. It cannot be just approved because, yes, we got the report from the town engineer. The other thing I would just say about conditions precedent, I think it's a very good idea to make sure you put in your regulations or on the terms and conditions of approval that the conditions have to be satisfied within a certain time frame, and or the planning board will bring the application back before the board to revoke the approval if they haven't met those conditions, so the plan can be signed, or that the application will be deemed no longer valid if the conditions precedent have not been satisfied within 6 months, subject to an applicant's request to extend that time period. I'm going to try to move through the last few slides, give a little time left over for some questions. Grandfathering rights is an important element of the decision-making process by the planning board. So projects that are approved by the planning board have to commence active and substantial development or building after the plan is recorded at the Registry of Deeds or given final approval by the planning board within 24 months. You really should plan to define what do you mean by active and substantial development. Does active and substantial development mean they put a shovel into the right-of-way and turn the shovel over with a shovel full of dirt, or are you going to require some degree of completeness of that road or other element? You need to define that. Otherwise, it'll be defined for you by someone else. You also have the ability to define what is substantial completion of improvements. So if a project has started active and substantial development within 24 months, and then completes active substantial completion of improvements within 5 years, they're absolutely protected from all changes in your regulations, subdivision, site plan, and zoning permanently, except for changes in impact fees. So defining those things in your terms of approval is an important part of the decision-making process. And then finally, I don't have a slide on it, but I apologize. I do have a slide on Housing Appeals Board. So if you're aggrieved as a planning board applicant, you can appeal to the Superior Court. for a writ of certiorari under RSA 676:15 within 30 days of the date of the decision, or now, if you are aggrieved by the planning board decision that relates to questions of housing and housing development, you can appeal to the Housing Appeals Board. The Housing Appeals Board is made up of 3 people, one of whom is an attorney, one of whom is represented real estate interests, and one of whom is a surveyor or engineer. And the Housing Appeals Board has been issuing decisions since April of 2021. I think there's about 20 decisions available for you to view if you want to have more insight. Some of these interesting zoning and planning decisions, which are now available at the Housing Appeals Board website, and they have public hearings, and you're able to attend these. I think you can also attend these public hearings remotely. And so they are there as an alternative method of appeal. So the applicant who has a housing project of housing and housing development can either appeal to the Housing Appeals Board or they can appeal to Superior Court. And it really depends on the project and which direction they would take. But clearly, the Housing Appeals Board is a much more expeditious appeal process. So with that, I've hit 11:58 and happy to take any questions that Stephanie might have for me at this point.
Okay, thank you very much, Steve. Once again, just a phenomenal presentation. We do have several, and obviously it looks like we're going to run over. If people need to leave, we understand that. If Steve is willing to get through the questions, that would be helpful. And we'll move on from there. As a reminder, we've been saying throughout that this recording and the slide presentations will be available on our YouTube page next week. And they are free. So let's get through the questions, and then we'll hopefully won't run over too much longer to get everybody out for enjoy this day. So the first question from the chat: what is the consequence of failure to meet once during a particular month for the planning board?
There is no consequence, so it's not like you're going to be drawn and quartered or arrested or anything like that. So it's just a good idea. Just plan to do it. And certainly there are going to be occasions where, and I think this happened certainly during the pandemic, where the planning board couldn't meet. And even though there was a short period of time where they really didn't have the authority to do virtual meetings. And that was until the emergency order number 12 came out. So I wouldn't fret about it a lot, but I wouldn't ignore it. You are obligated to have those meetings once a month.
Okay. There was a question from Doug Smith. I just want to make sure that it was answered. It kind of seemed like it was a follow-up when it must have been when you were talking about the ex officio members, Steve. And the question is, so a selectman's representative, correct? So if Doug just wanted to throw something into the chat to make sure that his question was answered, we would appreciate that. And Katie, it looks like we have one person that is on the phone that maybe would like to chime in.
We do. We have Nelson Disco again. So I'm just going to allow Mike. Okay, Nelson, you're able to unmute yourself and ask your question.
Okay, hello, can you hear me?
Yes, we can hear you.
Yes, good job.
Yeah. Steve, a question regarding the reasons for waiver. You cited 2 of them there that you said would allow a planning board to waiver certain requirements in their regulations in a particular case. And we have that same regulation in our town. And the question is that sometimes I find that I'm looking for a waiver request that doesn't seem to quite fit those 2 requirements, but I still want to grant the waiver. For example, we get a lot of revisions to existing approved plans that have been on for a number of years. They want to do a little expansion in one area. The board's agreeing to it, and yet we don't need a new lighting plan for this site. We don't need a new drainage plan for the site. And but those seem to be the only ways I can give him the waiver, theoretically, if I read literally what you've written there.
Well, yeah, I guess I would say this, Nelson. I think in that circumstance, let's the drainage example, maybe the applicant is adding a little bit more impervious surface. I think you could reasonably say, well, okay, it is more impervious surface, and technically the rules of our regulations might require a new drainage calculation. On the other hand, we can reasonably conclude the change is going to be de minimis. So we can decide waiving in this setting is not contrary to the spirit and intent of the regulation. Spirit and intent of the regulation is to make sure drainage is handled on site and doesn't flow off site. And we think we can do that here. So I think you can still fit it into those particular two categories. The other category, of course, is it's still going to carry out the spirit and intent of the regulation. What's your job as a planning board? To make sure that site plan fits harmoniously in its neighborhood. And you've concluded, yeah, this change with more impervious surface is still going to be sufficiently harmonious and not cause off-site drainage impact. So I think you can still fit it into those criteria.
Okay, just a little bothersome, but I guess I can live with. I've been living with that. Thank you.
Okay.
Thank you. We have another person on the phone we'd like to try and get in.
Nope, that's it.
Okay, thank you. Okay. Is there a remedy for prolonged absence of a member?
Yes, there is. There is a provision that governs the removal of land use board members. It's RSA 673, and I want to get to it here for a second. 673:13. So appointed or alternate or elected members can be removed for inefficiency, neglect of duty, or malfeasance. So if you're not attending, and you might indicate, what that would be in your rules of procedure, 4 consecutive meetings of the planning board without excuse, you could probably conclude that's neglect of duty. And although the judgment on that neglect of duty that might result in removal has to be made by the governing body. But I think that's how you would approach that issue. Consider it failure to attend would be neglect of duty.
Okay. Along here. Does the preliminary consultation need minutes and an invitation to all planning board members?
Oh, it's a public meeting, just like any other public meeting. And the public has a right to attend. Notice has to be given to the public and minutes have to be kept. No question about it. There's no exemption from that provision of the statute, and that would be recorded in the minutes, the give and take between the applicant and the planning board.
Okay. Just as a follow-up, kind of a similar question, can we hold preliminary reviews without mandating them by town meeting? But actually, I think, are you talking about the technical review?
Well, okay. So I guess what I was trying to make clear is if you want to require preliminary review in your regulations, the town meeting has to allow you to require it. You don't have to require it. You can recommend it, and that's okay. I just feel it's the better way for a planning board to require conceptual consultation. And to do that, the town meeting has to say, yes, you're allowed to require conceptual consultation.
Should a planning board conduct preliminary conceptual review on extensive, detailed engineering drawings submitted by the applicant?
That sounds more like design review. And that's the route that I would encourage them to take. I think, if you have very comprehensive plans and the materials, and they would constitute, in essence, what would be considered a completed application, that's probably the route to go. I mean, I think that the conceptual consultation is really designed to allow informal consideration of an application, informal, including the nature of the materials that are submitted for consideration.
Okay, very good. Does complete application hinge on its meeting state and local guidance in addition to meeting the application checklist, that is?
It's a great question, and there's actually a provision of the statute that was amended a couple of years ago, which addresses that issue. And it's in RSA 2:4. And what it says is, it says an application should not be considered incomplete solely because it is dependent upon the submission of an application to or the issuance of permits or approvals from other state or federal government bodies. So you might say, as part of a final approval or conditional approval, this application requires an alteration of terrain permit or a permit from the Army Corps of Engineers or from the Wetlands Bureau. But you wouldn't do that as a preliminary determination. We have to have those pieces of information as part of plan acceptance. That's part of plan approval, not plan acceptance.
Okay. Very good. What is the threshold for regional impact?
Just the things that I mentioned. The threshold is, a reasonable determination that a project is likely to have an impact on an adjacent community. So as the slide indicated, and there's no, I think, particular level of impact that's going to trigger a judgment that it is a development of regional impact. You have to take into account, I suppose if you have a 2-lot subdivision that is adjacent to another town, and that 2-lot subdivision doesn't depend on that adjacent town for any elements of its use, such as road networks. They just happen to be 2 lots that are on a town border. That's pretty de minimis. But if you have a 20-lot subdivision that's going to have a road that leaves the subdivision that's going to go into an adjacent town road, I think now you've triggered a likely one of regional impact abutting an adjacent community. But I can't give you a hard and fast, if it's this, it's a DRA versus that. Those are the things you have to take into account and make a reasoned judgment as the planning board. Is it a development of regional impact?
Very good. Bonnie Ham has a question. It's maybe a follow-up to another one. So Bonnie, if you're still on and would like to clarify that, because your question was, this only applies if zoning, right? So I'm not sure what that's a follow-up question to. So if you're still around, throw something in the chat so we could maybe get an answer for you today. What keeps a board from noticing an issue and attempt an amendment and delay acceptance to ensure the first notice is sent to the application is now burdened by the new amendment once adopted?
So DHB versus the town of Pembroke, which I'm very awfully familiar with. So I think it'd be bad faith. I think that's what the planning board did in the Pembroke case, because I was there at the public hearing when that happened. If the planning board intentionally delays plan acceptance so that they can post a proposed zoning amendment that would make the project illegal and then avoid the acceptance vesting, that's just bad faith. And I don't think towns should do that kind of thing. I think in the normal course of events, if an application comes in and they're close to zoning amendment time and there's a potential that it could affect the project, I think the board has to reasonably work with the applicant and not play games with when the matter gets scheduled for public hearing or public plan acceptance, so that they can try to trigger, that the as you all may know, a zoning amendment goes into de facto effect during the period of time 120 days prior to town meeting, as soon as the planning board gives notice of the zoning amendment. So there's a little bit of good faith that has to be applied on both sides of that equation, especially where there's a project that's pending and everyone knows about it, and now there's a zoning amendment that's being used to potentially affect that project. There's a heightened degree of responsibility on both sides to reasonably address plan acceptance in a timely fashion, but not unreasonably delay the planning board's effort to get a proposed zoning amendment that the board thinks is important. That's really the best way I can say about that one.
Very good. I think this may have to do with DRI, and if Jane is still on, maybe she can clarify for it. The question is, what does the first bullet really mean? What proportion of existing stock makes regional impact kick in?
Again, I don't know that I can give you a hard and fast. What degree of size? Let's just talk about the first bullet. relative size or number of dwelling units as compared to existing dwelling units. So if you have a community with, let's say, 500 dwelling units, and we're going to add 2 more, that's pretty de minimis, especially if that 2 more is adjacent to the, the neighboring community's boundary. But if I'm adding 50, which is 10% of the existing housing stock, well, okay, now that's a lot. And so we can probably in that situation say, that is not insignificant. The relative size of that additional 10% of housing right on the municipal border is likely to have an impact. But then you factor in these other issues. Will the road network for this 50 new lots be impacting the roads in the adjacent community? Because if the easiest way to get to the nearest interstate is through the adjoining town, and that's where the housing is going to be located, that's going to have an impact. And you have to take those, evaluate those factors and make that judgment. Is it development or regional impact? But keep in mind, the statute also says very clearly, resolution of whether a project is one of regional impact will be resolved in favor of making such a finding. So you're supposed to resolve the issue of, is it a project of regional impact, in the light most favorable to making that finding that it is a project of regional impact.
Yeah, now just quickly throw in my 2 cents. I have seen some planning board subdivision and site plan regulations out there where they actually, the board, whether help with their planner or help with their RPC, has come up with thresholds and guidelines. So that maybe that's something, if you want to reach out, everybody out there, to your local planning staff or to your RPCs, where they say if, between 1 and 50 houses or 500 and 200 houses, but you can work with some professional planning staff to come up with some guidelines with, of course, the caveat at the bottom or anything else that the planning board sees fit. I mean, we can't anticipate every use, but if there's going to be 400 houses in your town, in 2 years, maybe that application should be reviewed as a DRI. Those types of things are things that you can look at. So if you have any interest in working on that, reach out to your RPCs or if you have planning staff to do that. It's helpful to have the thresholds listed out if you're able to. If the applicant's engineer is the town's engineer, what do you suggest?
Get another engineer to review that project. Seriously, you have to.
Yeah, that's a little bit of a conflict.
Yes.
And again, another just follow for regional impact, just to make sure we're answering your questions. And regional impact, is there a threshold building size for non-residential building area?
I think it's more important is to how does that building size reflect an impact on the neighboring community? As I was talking with Nelson Disco about, impervious surface and offsite drainage impacts, the topography of the property, its nearness to, subsurface waters, how much impervious surface is going to have, how it's going to control, because stormwater management is part of our obligations under the NEPDs 2, the National Pollution Elimination Discharge, NEPDs 2, Roman 3. I don't remember what stage we're at now, but the stormwater management is an obligation under the Clean Water Act, and you just have to make that assessment. I mean, if it's a project of significant impervious surface that's going to have an impact on drainage and surrounding surface waters, yeah, it's going to have a project of regional impact. On the other hand, if it's a small strip mall with, well-handled on-site drainage and very minimal traffic impact, probably not a project of regional impact. It's one of degree. And I don't think there's a bright line rule one way or another.
Very good. At the beginning of this workshop, Steve, you seemed very welcoming of questions from members of the public bodies. My town says only the administrative assistant, zoning administrator, and chair of the select board are authorized by virtue of their positions to consult town council or NHMA attorneys at any time. Is this policy unusual? If I have further questions, should I pass them through the select board to ask you?
Well, I can only speak to the NHMA Legal Advisory Service. We do have a policy. that if a town chooses to limit who has access to the NHMA attorneys, myself and Jonathan Cowell, that is their choice. And if they implement that limitation, we're obligated to abide by it. As regards to town council, we're a little bit different than town council because town council typically charges by the hour. And certainly the select board has an obligation to ensure legal resources are within the budgets allocated by the town meeting. So it may be necessary to limit who can contact town council to control as a budgetary item. Now, NHMA, people join and they pay an annual dues. So, and it's just a capped amount. And we have certain towns that we spend a lot of time answering questions for, and others who don't call as often. And that's the nature of our legal advisory service. The local choice to control access to town council NHMA is really a local choice. And all I can say is if the select board has elected to limit who can contact NHMA legal advisory service, that's their choice. And we have to abide by that choice because the member can make that decision. That's really the best I can say.
Thank you. Are impact fees required to be expended in a set period? Can this period be extended?
So let me just, I didn't really talk about impact fees under the statute. I talked about exactions. So better to call it an exaction, a planning board assessment of an offsite improvement expense. I guess I would say this. There is a requirement in that statute that the money collected under an impact, under an exaction be expended within 6 years, I think it is, of a collection. Hold on a second. Let me just look it up real quick. So you have that time period. Could it be, is it possible you could extend that time period? Let's see. I will tell you as soon as I find that provision. So it says, whenever they a refund of any collected exaction shall be made to the payor or payor successor in interest if they fail to allocate or spend within 6 years of the date of collection. So I guess, is it possible for an applicant to agree in writing to a waiver of that 6-year time period? Yes, they could. And that might be sensible because, we've asked the applicant to pay their fair share of the cost of building a new intersection, maybe with lights. And maybe that whole project has been delayed in the 10-year plan, but the applicant has agreed they're going to allow that dollar amount they've contributed because they know they want that light built, and it won't get built unless their share is contributed. So yes, the applicant can consent to that and allow that time period go beyond the 6 years because just of the timing, especially that's true with transportation on state highways as related to the 10-year plan.
Okay, thank you. Third-party consultant reviews, can these be requested at any time during the review and not just limited to this at the start of the process?
I think it's the better practice to try to give that assessment to the applicant so they can then budget and plan for those expenses up front and know what they're expecting to pay for review expenses, which is typically only limited to engineering review. But if something comes up during the course of the project, which dictates, another example would be all of a sudden we find, especially either at a site visit or later on, there's a significant wetland which was not well described in the plans, but now is going to have a potential impact because there's going to be a change in the road network, and the road is suddenly going to be impacting the buffer of the wetland. Certainly, you could say that now we need to have a soil scientist give an opinion about the functions and values of that wetland and how we're going to protect it. So you're not limited, but I think you really should have a good reason to deviate from what you've already told the applicant are the likely expenses for consultative services to assist the planning board, which is the better practice to do that at the commencement of the application.
Okay. I think this question is related to allowing people to speak at a public hearing. What about folks from out of town and not a taxpayer in the town? to be allowed to speak?
Well, when you've scheduled a public hearing, you trigger the First Amendment with regards to this being a limited public forum. And, so long as the people speaking are to the subject and not some wild, crazy concepts unrelated to the application itself, I would be very cautious to say that non-residents are prohibited from speaking at a public hearing, so long as they follow the rules, that it's going to be germane to the subject at hand. They're going to be limited to 3 or 5 minutes, and they can't have repetitive comments. So one of the things that I've seen occasionally on a project that's particularly objected to by those in town or by people who live nearby, you have person after person coming up and making the same comment. Repetitive comments are disruptive because they prevent the board from doing their job. At some point, the chairman has to say, wait a minute, we've just had 5 people say the same thing for 5 minutes. Those are repetitive comments. Repetitive comments are disruptive comments because they're impeding the board's ability to do its business. So I'm going to say anyone else who wants to say the exact same thing, the same person just said the same 5 people said the last 5 times, that I'm not going to hear that anymore, because that's a reasonable control of time, place, and manner. But I would just be very leery about a planning board saying we're going to prohibit non-residents completely. I think you're on a dangerous ground with regards to the First Amendment. I don't think that's an appropriate approach for the planning board to take.
Okay, very good. What happens if 6 members present tie vote and the missing 7th member shows up to vote at the next meeting and one of the original 6 isn't there and the vote changes? That seems like it could be taken advantage of.
Well, the missing member is privileged to vote so long as that member can demonstrate, and there's a case on this, the Greenland case. I think it's Sanderson versus Greenland. So long as the missing member can demonstrate they have adequately studied the record from the prior hearing they missed so that they have a sufficient basis of knowledge to now make a decision. They're going to have to read the minutes. They may have to watch the YouTube link. They may have to read the materials that were submitted and considered at the last public hearing that resulted in the tie vote. The new member who was missing can then vote at the subsequent meeting, even though one of the members who vote otherwise is no longer there. That's okay, but the missing member has to demonstrate that sufficient basis of knowledge and study of the record in order to justify participation in making a decision based upon something they missed at the prior meeting. Now, that also presupposes that member who was not at that meeting had attended all the other meetings. So all they missed was the one. So they really do have probably an adequate foundation of knowledge to say it's justified for them to participate in the meeting that is now the follow-up.
Okay. If there are 6 members, 1 abstained, 3 yes, 2 no, you have a positive vote, right? Or
well, no. Okay, so just to understand, if I abstain and don't recuse, I'm deemed to have voted with the majority. That's the law. So abstention is not appropriate because you're not doing your job as a member of the planning board. You've got to vote. You can't just say, I don't want to vote. You can recuse because you got a conflict of interest. You can't just abstain because you want to. So anytime you abstain, just remember, you're deemed to have voted with the majority. So now that vote is 4-1.
Okay. Okay. So the rest of the question, just for clarify, or 4 of the 6 are present, 1 abstains, 2 yes, 1 no, have a positive vote.
You now, the person who abstained is deemed to have voted with the majority.
Okay. What does a planning board have to do if they approved a site plan, subdivision, or merger and find out later that they have violated some ordinance in doing so? For example, allowing a merger across a public right-of-way.
Well, yeah, merger can only occur for abutting properties. What should the planning board do? I guess that begs the question, does the planning board have an independent obligation to police its own decisions? and to bring the matter back before the planning board to make a new decision, which may create even more disharmony and disruption amongst those who are participants to that original decision. I don't know that I can give you a blanket, this is what you should do under all circumstances of that situation. I think that's going to be context specific, and you're probably going to have to seek the advice of town council on what to do in a particular set of circumstances. I don't know that I can give you an overarching, this is what has to be done in those circumstances.
Okay. One more question about abstention, just to make sure that his question gets answered, Steve. What happens if a member abstain vote causes a tie in a final decision vote?
The member who abstained is deemed to have voted with the majority. So his vote goes on the winning side. So if it was 2-2 and he abstained, it's now 3-1. That's how it works. So if you think you're doing yourself a favor by abstaining, you're not, because you're deemed to have voted with the majority.
Good. What are your recommendations for how to make clear who is voting in deliberations or when a motion is made? Do you suggest alternates be asked to leave the table?
Well, alternates don't have to leave the table, but I'll just say what we do at my ZBA, the first thing the chairman does is say, like just the other night, we had 2 alternates who were there, and there were 2 regular members missing. So the first thing the chairman does, okay, so tonight, Steve is going to be voting because Dan isn't here, and Paul is going to be voting because Charlie isn't here. And then there were 2 other regular members plus the chairman. So that composed the board of 5. So he designates who's sitting that night right then. And so there may have been another alternate in the room who wasn't going to participate, but he made that designation at the beginning of the process. And you could do that either at the beginning of each hearing or just the beginning of the night. So it's clear who are voting members that night. But doesn't mean that alternates have to leave the table. It's just that the chairman has to designate who's voting that night, who's substituting as an alternate for a missing member. Now, this might come up later on during the meeting, because during another particular application, it may be that Steve has to recuse himself because the applicant's his brother-in-law. So then the chair has to redesignate someone to sit for Steve as an alternate. But the alternates don't have to leave. They just, the chair has to designate who's a voting member on that application. That's the chairman's job.
And Steve, for clarification on that point, is it okay for if no alternates are designated, but they're there at their meeting, they're participating, they're asking the applicant questions, they can participate in the deliberation, they just can't vote, correct? Or do they not participate in the board deliberation?
Okay, so I'm going to read the statute because I don't want to miss the point on this. So that's in 676(1). And it says, the rules of procedure shall include when and how an alternate may participate in meetings of the land use board. That's what it says. That's 676:1. That's fairly broad. It's not saying that the participation is limited to the public hearing process. It certainly could include participation in the deliberation process. But I think the key thing here is the statute calls for you to say in your rules of procedure how you're going to let alternates participate. The board has to decide its rules. Can they only participate during public hearing, or can they participate during the deliberation process? You should specify that. And I think the statute, that provision could be read to permit either, but that's a choice the board has to make in its rules.
Very good. Okay. Is the ex officio a voting planning board member? I think you answered that.
Yes.
Then I was looking for examples of ex officio members, and I believe he answered that too. The selectmen.
Well, selectmen, they're like, for instance, I was looking at this the other day. A member of the Heritage Commission is an ex officio member to the Historic District Commission, and vice versa. So there are other ex officios. There aren't a lot of ex officios by statute. One that is obviously most well known is there's a select board ex officio member on the planning board.
Okay, very good. Jane, if you're still on the call, she said you missed my question about the bullet related to regional impact. I think we answered that. If we do not get your question answered and you're still online, you could feel free to shoot us shoot me an email, and we'll get that figured out for you. And again, there's another kind of loose question here, but if they are elected, they serve until next election. I'm not sure. Is that about appointing members? So if Bonnie,
Yeah, I'm not sure about that.
yeah, if is it Bonnie?
If
Your
that's
question.
if that's a situation where they're switching from elected to appointed or appointed to elected, there are some time periods that might come into play.
Oh, okay. Actually, Bonnie, I think has her hand raised. Is that you, Bonnie? Are you on the phone?
It is, yes. Let me
Okay.
allow her to unmute herself. There you go, Bonnie. You can now unmute yourself. In the top right-hand corner is the mic button. Maybe? Okay,
Can you hear us, Bonnie?
I'm not seeing her unmute herself, so I guess let's move on and we'll see if she figures it out, or maybe it was an accidental hand raise. I don't know. So.
Okay. Yeah, so that is just that question out there of whether or not supposed to be about appointed or elected versus members. Someone's asking, I believe ex officio has the same abilities as the member they represent.
The body they represent.
Yeah.
So they have the same status as any other member of the planning board. They are there, obviously, to give the opinion of the select board, but they are a full member of the planning board.
A full voting member.
Yes.
Okay. I think we could be wrapping up to the end here. Let me just catch up. Someone's making a statement. This was the issue with the town of Durham versus Mill Plaza in 2007 as another example of this. I'm not sure what another example of this was. Hillwood project was quickly decided because it was obvious, use common sense. Okay, I think we're approaching the end. Just making sure. If a member is late and an alternate has been assigned, does the member then regain their voting position and the alternate unassigned?
That is a judgment for the chair. As the statute provides, it's the chair's duty to make the assignment of those who will sit for absent members. So I would defer to the judgment of the chair and/or your rules of procedure. I have no specification on that.
Where does business of an abstention being considered an additional vote with majority come from? Not
McCrae versus the town of Merrimack. It's actually a Supreme Court case, which actually was decided previously in a decision called the Opinion of Justices. And then later on, most recently, it was in the Supreme Court case of McCrae versus the town of Merrimack. And so it's right on point. And what happened in that case was a select board member tried to recuse to rob the select board of a quorum to make a decision. And the Supreme Court said, no, you can't do that. You are deemed to have voted in the majority. By the way, I see someone who says it's not Robert's rules. Oh, yes, it is. Robert's rules of order say the very same thing. If you abstain, you're deemed to have voted with the majority. And I can't pull it out right now, but I've found that in Robert's rules before.
Okay. Can a planning board member speak against a project at the ZBA? Does the planning board member have to recuse themselves when the project is before the planning board?
If a planning board member has come to the ZBA to oppose a project that requires zoning relief, the project gets zoning relief, and now the planning board member is sitting at the planning board to approve the site plan, that planning board member has expressed an opinion, a prejudgment on the same application. That member should recuse themselves.
Okay. Is Bonnie back on the phone, or we have another hand raised, Katie?
Yep, I never saw from Bonnie, but we do have one more hand raised.
Okay.
James Prieto, I apologize if I'm pronouncing your last name wrong. But you should be able to unmute yourself now in the upper right-hand corner.
Stephen, this is James Prieto. You actually just answered my question regarding planning board member speaking out at a ZBA and then
Oh,
hearing
okay.
the project. So I appreciate it. Thank you for your time.
Okay,
You guys did a
great.
great job.
Great,
Thank you.
thanks, James. Okay,
And we have no more hands raised on the call-in, so.
okay. And I think what we're kind of wrapping up with here, appreciate Steve, this is all about you day. So we appreciate you staying with us and we still have about 50 people who have stayed on to enjoy you and to ask more questions. So we appreciate that. Just as a clarification here, someone's saying, as far as the alternate having been assigned, I think they remain for voting since the board member was not there for deliberations.
I would defer to the chair and the rules of procedure for that board.
Very good. Okay, I think that we got through all the questions. Again, if I've missed anyone, please, jump on the website, send me an email. I'll be glad to sort through your question and get it to Steve. If it's something that Steve would be interested in helping out with after the fact. So thank you everyone for attending today on this beautiful sunny spring day. Most importantly, thank you to Steve for staying with us and volunteering his time. Steve, you're the best. We really appreciate it.